If you have a temporarily disabling injury, illness, or other condition, you may be entitled to receive benefits under your employer's short-term disability plan if offered as part of your benefits package. Even if you have a legitimate and well-supported claim, it is possible that a third-party administrator or the insurer will wrongfully deny your claim or otherwise delay, redefine, undervalue, or mishandle your benefits claim. If the insurer has made a decision adverse to your interests, then it's important that you consult a qualified attorney for guidance on how to proceed. Short-term disability benefits are a form of temporary wage replacement that may be available to claimants who demonstrate that their condition imposes an impairment of such severity that they are incapable of performing the primary duties of their occupation for a period of time. The benefits payout may be calculated as a percentage of your total wages, or it may be simply a specific pre-negotiated amount paid on a weekly or a bi-weekly basis. Short-term disability benefits coverage may last for as little as 30 days to as long as 26 weeks, after which point you will need to apply for long-term benefits if you have a qualified plan and you are still suffering from the disabling condition at issue. Some short-term and long-term policies are integrated, however, making it easier to transition coverage. Every plan is different, but generally speaking, short-term disability coverage requires that you be employed full-time, the satisfaction of a waiting period before benefits are payable, and proof of a disabling condition that prevents you from performing the normal duties of your occupation. There are a number of issues unique to short-term disability coverage, denials, and subsequent appeals. Unlike long-term disability benefits potentially paid for a lifetime or until retirement, short-term disability coverage is quite limited. Given that benefits are paid out for only a limited period of time, up to a year in some plans, there is substantial pressure on the claimant to avoid committing too many resources, money, time, and effort into fighting the wrongful denial of their benefits. If the disability is severe but recovery is expected, a claimant may feel as though a better use of his or her limited resources would be to focus on getting healthy and returning to work. This is particularly notable as, if the claimant were to return to work, they would almost certainly have no basis on which to challenge the denial of benefits, as the insurer would argue that the condition is not disabling if the claimant can simply return to work. Temporary disabilities are subject to greater scrutiny as a general rule, given the fact that they are limited in time. There is an implicit understanding that the disabling condition will be resolved with adequate care and treatment. Some short-term disability insurers require frequent medical updates so that they can keep apprised of the claimant's condition and determine when exactly the disability has been sufficiently mitigated so as to reduce or eliminate benefits altogether.